to get us started. First of all, thank you all for coming. My name is Carol Levine, and I'm the chair of Courts Matter Illinois. And I want to welcome you, and we're very grateful to have all of you here tonight. I want to open the program just with a few thank yous, and then I'm going to move over to the middle seat over there and let my colleague Victoria take over for me. But I wanted to start with a few thank yous because I think it's very important. This program would not have happened without a lot of hard work on the part of a good number of people, one of whom is standing next to me right now, Victoria Trujillo, who is our outreach coordinator for Courts Matter Illinois, made an awful lot of the things that happened, that brought about this event, take place. Without her technological skills, none of this would have happened because you are looking at a Luddite when it comes to technology. The other person I need to thank personally is Dana Pownall from Chicago-Kent College of Law, and our sponsors, the American Constitution Society, and particularly the Chicago-Kent Student Society of the ACS, who have been fabulous in helping us. They're the people you see handing things out. They're the people who have helped us get things set up. And we could not have done this without their sponsorship and their help making this happen. We have two other sponsors who have been really enormously helpful. One is the law firm of O'Malley and Madden. We thank them profusely. And the other is Planned Parenthood of Illinois, one of our members of our steering committee, and someone we want to thank as well for helping us put this event together and making this all happen. So we are very, very grateful. And I just wanted to begin the event with the thank yous rather than ending it with the thank yous. And with that, I'm going to turn the microphone and the podium over to Victoria, who's going to make the introductions. Thank you.
Well, thank you all again for being here. All right, so I just wanted to take 1 minute to tell you just a little bit about Courts Matter Illinois. Courts Matter Illinois is a coalition of diverse organizations and individuals working to create a federal judiciary composed of judges committed to upholding our core constitutional values. And when we say that, we mean things like civil rights, workers' rights, freedom of speech, separation of church and state, all those things that we value so much. And so basically what we're saying is that we believe that federal judges should be fair-minded constitutionalists protecting the rights of all Americans, not narrow-minded elitists who are only protecting the rights of a few. And we do that by holding events like this one. We hold events and trainings throughout the year. If your organization is interested in having us come lead a session, we'd be more than happy to do that with you. We work with our elected officials. We send sign-on letters, letters to editors, and other things to make sure that all of our members have the chance to make their voices heard on this incredibly important issue. And with that, I'd like to invite you to join us. I know some of you joined us on our email list outside. Thank you. You can also follow us on Twitter at Courts Matter IL or on Facebook at Courts Matter Illinois to get more updates on events like this, articles related to the nominations, decisions, and far more than that. And so with that, I'm going to go ahead and get us started. I would like to introduce our speakers tonight. I'm going to begin with Ms. Dahlia Lithwick. Dahlia Lithwick is the senior editor at Slate, and in that capacity writes the Supreme Court dispatches and jurisprudence columns. Her work has appeared in the New York Times, Harper's, the New Yorker, the Washington Post, and Commentary, among other places. Ms. Lithwick has testified before Congress about access to justice in the era of the Roberts Court. Ms. Lithwick earned her BA from Yale University and her JD degree from Stanford University. Thank you for being here. Need to be a little bit less enthusiastic. And I'd also like to welcome Jeffrey Stone. Jeffrey Stone is the Edward H. Levi Distinguished Service Professor at the University of Chicago. Mr. Stone received his JD from the University of Chicago in 1971, where he served as editor-in-chief of the Law Review. After serving as a law clerk to Justice William J. Brennan, Jr. of the Supreme Court of the United States, he joined the faculty of the University of Chicago Law School in 1973. Mr. Stone is the author of many books on constitutional law, and his next book, The Free Speech Century, will be published this fall, so keep an eye out for that. Thank you as well for being here. And finally, our conversation will be moderated by the wonderful Carol Levine, the co-chair of the steering committee for the Courts Matter Illinois organization. And we'll go ahead and get started.
Thank you. I'm going to just tell you how this is going to operate, and that's probably the most you're going to hear from me. Okay? We're going to have brief introductory statements from both Jeff and Dahlia. Then we're going to go to discuss 6 cases that were before the Supreme Court this session. We're going to have brief discussions. Each of our speakers will address one of these cases and the other will respond to what they say. Don't expect disagreement. Just tell you that up front. But they're going to be looking at it from a future perspective, not a past perspective. Okay? Then we will have something of a closing statement from each of them. And then we'd like them to look at the future of the court, in particular the Kavanaugh nomination. And we might get into some of the information about what's happening today in terms of what's happening in the world today, since I don't think we can ignore that. You all have been given index cards on which you can write questions. If you have a question and you write something down, just quietly hold your card up. Our fabulous Chicago Count students will collect them, and they will be brought to me. They'll be looked at, and they will be brought to people who will screen them and bring them to me so we don't have duplicative questions. And we will try to get to questions and answers during the program. So we're going to start with opening statements. Dahlia, you're going to go first and take it away. I'm going to stop talking.
Oh, wait, I have to turn my thing on. Okay, can you hear me? So I want to just start by thanking Courts Matter, thanking Carol, thanking Jeff and all the folks who put this together, and also with just the precatory observation that what happened today was truly extraordinary. And I think we will save some time to talk about it because it's really, I don't think one could overstate how exceptional a day this was in constitutional democracy. Just by way of an opening, I think I would just make a couple points about this past term. I think maybe the most important takeaway is that to the extent that we had lived under the illusion that the U.S. Supreme Court was a sort of 4-4 court with a swing justice, I think we can probably put that illusion to rest after this term. There were 19 decisions, merits decisions that happened this year that broke on a 5-4 margin. Kennedy voted with the liberal bloc 0 times in that 19. So I think that we had become a little bit accustomed to saying, oh, Anthony Kennedy is a centrist moderate, he's more or less what Sandra Day O'Connor had been until he became the swing vote. I think, we could have a conversation about whether he changed or the world changed. I actually think it's a little bit of both. But to the extent that we liked to tell ourselves that Anthony Kennedy was in play, I don't think he was in play this year. What that means going forward, and we're going to talk about Judge Kavanaugh toward the end of the program, but going forward, understand that the most consequential thing you could probably take away from that is that effective October, November, if this confirmation happens, the centrist moderate at the U.S. Supreme Court will become Chief Justice John Roberts. And you've probably all seen the famous Judge Posner study from a few years ago that sort of lists for the past century the most conservative judges in history. Anthony Kennedy was 11, I think, on that list. John Roberts was in the top 5. So just to the extent that the centrist moderate vote on the court now is reliably on the very conservative block, tells you which direction we're headed in. The only thing I also want to say, just as a opening, and this almost is a cliche, but I'll say it anyway, it turns out that blocking Merrick Garland was the single most consequential act of the 2016 election, of the campaign going forward. It is not to rub salt in a wound, but I think it's fair to say each of the 5-4 cases we discussed today would have gone a different way had Democrats fought meaningfully to get Merrick Garland on the bench in 2016. And the very last thing I want to say, and then I actually, this is Jeff's area of expertise, not mine, but I think that one really amazing theme to pull out of this term is the weaponizing of free speech claims. The use of, I feel like every podcast I had was about weaponizing speech, so you're probably bored of hearing me say it. But I think that one really fascinating, and I haven't wrapped my head around it, but the notion that, the Janus case, the Unions case, Masterpiece Cake Shop, Becerra, the Crisis Pregnancy Center case, a lot of the cases we're going to talk about today come to the court dressed as one thing and become speech cases. And more pointedly at this moment, I think become speech cases about sort of aggrieved minorities feeling that they don't want to be forced to say something they don't want to say. That this is the singular laser focus issue of constitutional democracy right now is really an astounding place to find ourselves. And it's not entirely an accident that every radio show I did, I don't know if Jeff is going to say the same thing, but every radio show I've done in the past 2 weeks has involved some caller saying, I don't like Donald Trump, but he says what he means. He, speaks truth to power. He's not politically correct. And I think that intersects in a deep way with the big theme of the Supreme Court term, which is that people do not want to be told what they have to say, even if, and we're going to hear it in Becerra, and we're going to hear it in Masterpiece, even if what they're being told to say is true. So I'm going to stop there.
Well, I'm delighted to be here. I thank Courts Matter and Carol, and I'm especially delighted to have the opportunity to have this conversation with Dahlia. For those of you who are not regular readers and listeners to Dahlia, she is the best legal commentator in the United States today. I mean, I listen and read you all the time. I guess I'll begin by saying I started law school in the fall of 1968, 50 years ago. And that was at the heyday of the Warren Court. And our understanding of the Supreme Court, having grown up in that era, was that the court was fundamentally a champion of minorities, of individuals who were especially vulnerable in society, people accused of crime, that it was a protector of democracy, that it was a protector of free speech in the political arena, that it was in favor of one person, one vote, and that it was an active, but in a principled way, an active protector of the fundamental values of the Constitution. And within the next year, Richard Nixon defeated Hubert Humphrey, and Nixon appointed 4 justices to the Supreme Court, Burger, Blackmun, Powell, and Rehnquist. And that brought into being the Burger Court, which we thought at the time was unbelievably conservative. And I was a law clerk to Justice Brennan in 1972-73, the first full year of the Burger Court. And we thought that court was unimaginably conservative, even though it decided Roe v. Wade in that year, with the votes of 3 of Nixon's appointees. Since that time, the court has, with the exception of a few issues, grown increasingly conservative. 13 of the last 17 justices have been appointed by Republican presidents. And we've reached a point now where the court is politically polarized in a way that has almost never before happened in history. That the number of votes, and this will change even more dramatically if Kavanaugh is confirmed, will be 5 Republicans and 4 Democrats, depending on what president appointed them. That, in my view, dramatically undermines the fundamental credibility of the Supreme Court as an institution. It is not supposed to be a partisan political entity, right? In the Warren Court, Earl Warren and William Brennan were appointed by Republican presidents. And Felix Frankfurter and Tom Clark were appointed by Democratic presidents, and they were conservatives. And that continued over time, in which justices appointed by Democrats like Whizzer White, or appointed by Republicans like John Paul Stevens or Sandra Day O'Connor were at least moderates. Now we've moved to a point where the division in the court is incredibly partisan in a way that I worry undermines the very integrity of the court as an institution. And I think that poses a huge challenge for the future. And it's exacerbated, as Dahlia said, by what happened with Merrick Garland, which is one of the most dramatic instances in American history of the corruption of the confirmation process in the Supreme Court for partisan political ends. So on that high note, let me turn, what we will do is address briefly 6 of the cases decided in the last term. And I know that many of you are not lawyers, so we will both avoid being overly esoteric. So the first of the cases, which I'll begin with, is Masterpiece Cake Shop versus Colorado Civil Rights Commission. And the case arose out of the fact that the state of Colorado, like the state of Illinois, has a state statute that prohibits businesses from discriminating in their activities against individuals on the basis of race, religion, gender, national origin, and sexual orientation. And in this particular case, a baker, Jack Phillips, who is a very religious Christian, refused to make a wedding cake for a gay couple and maintained that for the law to be applied in a way that compelled him to make that wedding cake violated his rights under the First Amendment, both as a matter of free speech and as a matter of freedom of religion. On the free speech side, his argument was that the state cannot compel him to make a wedding cake, which he regards as an expression of his own creativity, and that will convey a message that he does not wish to endorse himself personally. And the Supreme Court has recognized the principle that it can violate the free speech clause of the Constitution for the government to compel individuals to convey messages that they do not wish to convey. So, for example, the court held that the state cannot compel students to pledge allegiance to the flag, or that a state cannot require license plates that bear the words "live free or die" over the objection of a car owner who wants to put a piece of tape over the state's slogan. And the court has said that the state cannot, in some circumstances, without a compelling interest, compel individuals to express messages that the state itself has dictated. So the question, one question raised in this case was whether this violated that principle. And the case would be different if, in fact, it was simply, I refuse to sell wedding cakes to gays, than if I refuse to make a cake that says, I love gay marriage, or here are two men on the cake. So the question is, at what point is it conveying a message that you're being compelled to express? The second issue in the case, and this was a complicated issue, frankly, and particularly because the facts were a little bit unclear in terms of exactly what the baker was objecting to. The second issue in the case was the baker maintained that, regardless of the speech issue, that to compel him to make a wedding cake for a gay couple required him to endorse or become complicit in an activity, same-sex weddings, that was directly incompatible with his sincerely held religious beliefs. And to compel him to do that was a violation of his free exercise rights under the Constitution. And this is, again, a complicated issue. In the 1960s, the Warren Court took a position on this question that was actually very sympathetic to religion. It took the view that if the state compels a person to act in a way that is directly incompatible with their religious beliefs, that it cannot constitutionally do that unless it has a compelling justification for doing it, but that otherwise it should defer to the rights of the individual. 30 years later, the conservative Rehnquist court effectively overruled that prior decision and said that it's too complicated. We don't really want to have courts be in the business of trying to figure out what is a really sincerely held religious belief. How do we know whether this is what's motivating the person or whether they just don't like gays or they just, in the context of that case, which involved Native American church using peyote in religious ceremonies, how do we know people won't just say, well, okay, now I belong to the Native American church, so you can't prohibit me from using peyote? So they said, no, as long as the state has a rational justification, then you don't have a First Amendment exemption. So the case posed a complicated question about how to resolve that. Okay, the court decided to duck the whole thing. It basically said in a 7-2 decision that the Civil Rights Commission of the state of Colorado had violated the Free Exercise Clause of the First Amendment because several of the commissioners had made statements during the hearings that the court interpreted as being hostile to the religious beliefs of the baker. They were dismissive of the notion that religion should be discriminatory towards gays and lesbians, or that people holding a religious belief really have a religious requirement that they not be complicit in these activities. And the 7 members of the majority basically ducked the issue by saying that because the Civil Rights Commission appeared to be unsympathetic to the religious beliefs, that in itself violated the First Amendment and was unconstitutional. Justices Ginsburg and Sotomayor dissented and basically said this is bullshit. But for the majority of justices, this seemed clearly to be a way of just avoiding the issue, putting it off to the future, waiting till they have the new 5th justice, and then they'll resolve the issue the way they feel like it.
And I think the only 2 notes I would add to that, they say, in Hollywood, they say, I'm going to give you notes. So I don't know what it means, but I'm going to just give you notes. I think the 2 things that I would just add to that summary are, one, Justice Anthony Kennedy, when he wrote his concurrence in Hobby Lobby, he said, in Obergefell, when he wrote his majority opinion, he said, this is going to be a thing. They're going to be religious dissenters, good people of conscience who have a problem with this. But also, the dignitary interests of the gay couples matter. And then Kennedy-ishly asked us all to work it out politely. That's how this case came to be. So in one deep way, I think that one of the reasons, when I say Kennedy just got bored of the rest of us, I think that he really did want to resolve this issue, this collision between religious conscience and objections and deeply felt beliefs that some public accommodation laws go too far, and all the dignitary interests of gay couples that he had written about, not just in Obergefell, but in Lawrence, he just walked away. And it's amazing because, as Jeff tells you, that means that the next time this case comes back, and it will come back, when the commissioners speak respectfully, which I think is the law of the case now. The law of the case is just speak nicely when you, are on your Civil Rights Commission. This issue is still on the table. And the other point I just want to make is that it dovetails so perfectly with the travel ban case, which I'm going to talk about, because I think we all saw Masterpiece come down and we said, wow, if the court is just going to laser focus on religious animus that's betrayed by a couple of comments, and I should add, you probably know, the comment that really stuck in Justice Kennedy's craw were comments about that one of the commissioners made during this proceeding, where one of the commissioners simply said, a lot of the arguments that you are offering up have been made to justify, slavery and and upholding civil rights laws, and that's all that was said, but that was seen as a sort of blistering anti-faith animus. And so then a lot of us that were stupid wrote columns that said, this must mean that the travel ban has to fall. Because the travel ban, as you remember, instead of the blistering animus that is, sometimes words like these were used to justify really horrifying outcomes. We had actual quotes from the actual president saying things like, this is going to be an actual all-out ban on all Muslims entering into the United States. It's on my website. But we were stupid because, as you know, in the travel ban case, it turns out that some kinds of spoken words about religious animus are worse than others. So just briefly, because I'm sure you all know this, the first version of the so-called Muslim ban was passed less than a week after Donald Trump took office. All of us grabbed our laptops, we ran to airports, we did things, we were heroes briefly. That ban, as it was originally constituted, singled out 8 countries, all Muslim majority countries, Iran, Iraq, Libya, Syria, Sudan, Somalia, Yemen, and said even green card holders from those countries, even visitors with an actual visa, everybody's out, and refugees, we're going to put a hold on all refugees. You may recall it was mayhem. Quickly, the courts enjoined that, saying this is insane. In March, the Trump administration refined the travel ban. That was travel ban 2.0. Now it was they took Iraq off the list, and they sort of fiddled with the waivers process. And oral argument was scheduled for October, and then in September we got the third travel ban, and that one had helpfully added 2 non-Muslim countries, Venezuela and North Korea, from which we have no travelers. But the idea was this can't possibly be a Muslim ban because, look, North Korea's on the list. And that was the ban 3.0 that went before the court on April 24th. And the reason I'm sort of focusing in on, there were 2 issues. One was a legitimately difficult issue, the statutory issue about the sort of scope of presidential power and how much power we want to grant the executive on issues of national security. There was a genuine collision between statutes. It was a hard issue, stipulated. There was a not hard issue, in my view, which was this a violation of the Establishment Clause in the First Amendment, because Donald Trump had said over and over and over again that this was going to be a ban on Muslims. And in addition, you may recall, right after the ban was effectuated, the first one, he went on television and said, we're going to take special care of Christian minorities from those countries and make sure that they are not swept up in the ban. So it looked a lot like something that was tainted by religious animus. And the reason this becomes interesting is in the first iteration of the case, when it comes up through the Fourth Circuit and the Ninth Circuit, the judges are really grappling with these tweets, with these statements. They have to make a determination about things that are said during the campaign, which may or may not be relevant. But it is certainly material that statements that were made while Donald Trump was president, when Rudy Giuliani goes on television and says, oh no, let's be super clear, it's a Muslim ban, we just cleared it up. So it wouldn't look like that, we went by the country. Does that matter? And initially, I think the courts and even the judges, in the appeals courts who didn't really want to think about tweets, did really grapple with what do we do with those statements of what is clearly religious animus. Long story short, by the time the case gets to the Supreme Court, 5-4, they decide entirely in favor of the Trump administration. And interestingly and pointedly, again, if you sort of layer it against Jeff's description of what happened in Masterpiece, John Roberts, writing for the majority, more or less says this isn't about this president. This is about the powers of the presidency and the office of the presidency. And we are going to stay within the 4 corners of the executive order as written. And we are not. He says, certainly, I'm taking some notice of the tweets and the comments and the interviews, But that's not what we're here to decide. We're making a decision about lawful executive power for national security, and we're out. We're not doing more than that. It would be unseemly for us to do sort of psychological work, trying to probe what the president intended. And you may remember in a dissent, Sonia Sotomayor literally writes the words, Donald Trump, Donald Trump, Donald Trump, and she writes every tweet and every comment and every statement, more or less saying the majority has blinkered itself completely to the reality of who this person is and what he was trying to do. And I think that the other two, there's a much milder dissent, Justice Breyer, who's very, very focused on a non-trivial issue of the waivers that are being granted, that the White House had sort of said, oh, we're going to take care of people with this waivers program, and it turns out that the waivers are not being granted. So Justices Breyer and Kagan are very obsessed with that. But I think that just the only other thing I would say about this is, in addition to being sort of a pretty terrifying rubber stamp for Donald Trump going forward and the lawfulness of any activities he takes, as long as there's a decent pretext that includes the words multi-agency review. Though it turns out that'll get you very far. But I think that what's really interesting is that, for me, this was really the first case about Trumpism. Quad Trumpism at the U.S. Supreme Court. There are a lot of cases about detention and lots of cases about the rights of immigrants, but this was the first case where the court had to either acknowledge that this is just not an ordinary president, or do what Noel Francisco, the Solicitor General, was saying throughout arguments, which is presumption of regularity. We presume that he is a normal president. He's no different than Mitt Romney. And I think that that really was profound, that the majority of the court said, we're going with the presumption of regularity. In some sense, I think that might be a good way to think about today. That's what I'd say.
So I have just two comments to add to that. The first is that in defense of the 5-member majority, that's the devil's advocate, you should hear that, courts have always been uneasy inquiring into the subjective motivation of legislators or executive officials and invalidating otherwise lawful actions because they determine that there was an impermissible motive that drove the action itself. And what they basically see if they do that is, well, now we have to start reading everybody's mail and asking everybody what they said to somebody else, and how do we know whether they were serious about it? And courts have generally said, no, we don't want to go there. And that's not an unprincipled position. But when you compare it to what they did in the Masterpiece Cake case, it's bizarre, because the exact same argument could be made there. Right? And yet, in that case, the justices say, no, this is unconstitutional. We're perfectly happy to look into this, where the comments were far less inflammatory and far less revealing than what was involved in the travel ban case. And the other thing to point out is this is just an example, and we'll see a couple of them here, but all over the place now, of these partisan divides. Right? Here you have the 5 justices appointed by Republican presidents vote to uphold the travel ban, and the 4 justices appointed by Democratic presidents vote to strike it down. And this is, again, to someone like myself, very disturbing. What are they doing? Right? Are they doing law? And if they are, what's the theory that would explain why they're on different sides of this? Right? Would they have come out the same way had it been a Democratic president and everything else had been more or less the same? This undermines the integrity of the court in ways that are deeply disturbing. Okay, the next case we'll talk about is National Institute of Family and Life Advocates versus Becerra. This was a case arising out of California. There are across the country, and in California, some 200 of these entities, which are basically organizations that are designed to provide pregnancy counseling to women, but that themselves are dedicated to being anti-choice. And so if women come to them, they will get advice about a whole range of reproductive issues, but that advice will never acknowledge the legality or the potential propriety or common sense or whatever of abortion, and will never inform these individuals about the availability of abortion, how to pursue it, and the fact that the state provides subsidized health care for particularly poor women in this context. And the state of California, recognizing that this was happening and that many women were being misled in important ways, passed a statute that required all reproductive health centers, regardless of whether they were this type or just the ordinary type, to make available to their clients information about the fact that the state makes available to women advice and reproductive health care services that, particularly for poor or vulnerable women, are subsidized by the state, including about contraception and abortion and so on, and to basically post a sign to this effect in their waiting rooms. And again, framing this as a compelled speech case, some of these anti-abortion clinics maintained that it violated their First Amendment rights, their free speech rights, to be compelled to provide this accurate information about the availability of publicly funded services and how to obtain them. And so they claimed that to require them to make this information available violated their rights not to be compelled to provide information that was accurate about what other services are available within the state and which are in fact subsidized by the state. And the case went to the Supreme Court of the United States, and the court, again, in a 5-4 decision, divided on the constitutionality of this. The 5 conservative justices, including Justice Kennedy, the 5 Republican appointed justices, held that this law was unconstitutional, that it violated the free speech rights of these particular anti-abortion clinics, and that therefore could not be enforced. The 4 democratically appointed justices all voted to say that this was constitutional. The legal analysis basically turned on the fact that the court had in the past recognized that, as I said earlier, there are circumstances where compelled speech by the government is unconstitutional, but it's typically in situations where individuals are required to make ideological statements that are incompatible with their ideological beliefs. Here, the argument made by the state was that that's not what this was about. This was about accurate, factual information that served an important government purpose to ensure that citizens of the state were aware of services that the state made available, this was in the realm of both commercial type of speech, where the court had long held that commercial advertising could be required to include information that is accurate about the various products that we buy, and also that it was professional information, that the court in the past had held that doctors and lawyers and others could be required to reveal information to their clients and their patients about various aspects of the services that they were making available to them. So the 4 dissenters argued that this was in that other category, that this was analogous to other cases that the court had decided involving both commercial and professional speech, and that it was simply factually true information, not ideological information. The 5 justices in the majority basically said, no, this is about a viewpoint. This is about advocating abortion by the state, requiring these entities to endorse effectively the advocacy of abortion, and this therefore violated their rights under the First Amendment. This is not an open and shut or easy case. As a lawyer, you could make the argument either way, as I think was true in the travel ban case. But again, the divide is so obvious and so stark in terms of pro-abortion, anti-abortion, right? The case is not about abortion, it's about free speech, right? But it's clearly the abortion issue that predicts and dictates the outcome in the case. And partly what makes it so disturbing is that the justices in the majority would clearly, for example, uphold a law, and indeed voted to uphold a law, that required doctors who perform abortions to reveal to their patients all sorts of information about supposedly accurate information, although not even always accurate, about the consequences of abortion, about the dangers of abortion, and so on. And the same justices said that's constitutional. That doesn't violate the free speech rights of the doctors. because the state has a sufficiently important interest in requiring this. And these are professionals, so you can require the professionals to reveal this information. So again, part of what disturbs me about the outcome in the case is not just the result, but the fact that, as I see it, it is being driven very much by factors that in a world of legal analysis should not be the determinative factors. And in this case, I think the dissenters have the better of the argument, given the precedents that the court had handed down. And that simply posed no constraint to the majority, who basically were acting out of their anti-abortion view, saying we are not going to stand for laws that require these particular entities to provide truthful and accurate information that is of great relevance to the clients in terms of how they deal with the fundamental issue that affects their lives.
And my only addition to that is I think that this is very much like Masterpiece in that it is originally briefed and argued as a religion case and a speech case. The Supreme Court says it's taking it as exclusively as a speech case. This is about compelled speech. The religion claims drop out. But when you read the majority opinion, it is clear that this is some special class of religious speech, and that's how it's being decided. And so this is another one of those cases that if it's about religion, let's decide it on the religion merits. If it's about speech, let's decide it on the speech merits. But now we're in the interstices of speech and religion, and we're kind of crafting a doctrine of speech about religion that gets different rules. And it's just incredibly, I mean, you really don't know what is in and what is out of that bucket. But more urgently, any kind of crisp doctrinal lines about medical speech or professional speech go away. The only other thing that I think is just interesting about this case, and this is where it was starting to become clear that Anthony Kennedy was giving up on the world, was that his dissent, his concurrence in this case, and I meant to say it about the travel ban as well, he started writing these kind of really they were like haiku concurrences, where it was like all this fury was being mashed into sort of small bits of thought. And his, in the travel ban concurrence, in fact, Rick Hasson, who teaches at UC Irvine, the day he read the Kennedy concurrence in the travel ban case, said he's quitting because Kennedy wrote this deeply strange concurrence, more or less saying that seems like bad stuff that the president is saying, but oh well, I'm quitting tomorrow. And it was hard to read it as anything but that. And I think in NIFLA, in the CPC, the Crisis Pregnancy Center case, we had a similar thing where Kennedy started describing the state of California as an authoritarian state that was this sort of weird, repressive, big brother state that was forcing clinics to, sort of say these truthful facts about whether there were licensed medical personnel on staff. So it was just such a strange, and, for somebody who has been as measured and as careful as Justice Kennedy was, I found those concurrences in both those cases just to be psychologically really odd. Okay.
Before we go to what I think will be the only, quote, good news case that we're going to discuss, I want to remind you, if you have questions, please write them on those cards and hold them up so we can collect them, and that will be helpful to us. Okay. Thank you.
Okay, so I'm going to launch into the one piece of good news from the 2017 term, and that was Carpenter. It's only limited in its precedential value, so it's not even really good news. But let's take a moment and be happy that this was a non-trivial privacy case. And I'll do it quickly because it's not at all clear that this is a big deal or a little deal. I'd be curious to know what you think. But the fun fact about Carpenter is that it has to do with whether your phone records can be seized by the state without a warrant. So it's sort of a classic privacy case, but it's this third party doctrine, which means that this is not the state putting a GPS on your car. This is not the state looking at your cell phone. We know now the Supreme Court has laid down markers that the government needs a warrant. This is a different set of rules around what happens when you give up your information to a third party. And so there's always been an exception to the warrant requirement if you voluntarily give your information, say, to a bank. Well, the state can get that with less than the requirement that they'd need to get a warrant to search something, that you own. So the question really becomes, and this is the fun fact, poor Timothy Carpenter is on this huge spree of robbing, I love this, phone stores. So it's a cell phone privacy case and a cell tower case, but he's actually robbing cell phone stores, which I find to be hilarious. Radio Shacks all over Michigan. So it turns out that he's part of some nefarious phone robbing, store robbing enterprise in 2010. And the government is able to track his every movement over 127 days, because every time, you don't know this, but even sitting here, even with your phone off, you're pinging off cell towers, and that locator information is telling the nice people that have your phone service contract exactly where you are all the time. So over 127 days, the police gathered information about where Timothy Carpenter was and when he was at home sleeping and when he went to church, everything. They, I guess, got over 127 days, 13,000 cell phone tower locations, which seems like an awful lot of kind of invasive information, and all this is done without a warrant. And so he makes a Fourth Amendment claim, and the argument that the government is making is, no, he's voluntarily given this cell phone information to his phone carrier. And again, it's a close case. I mean, under sort of traditional third-party doctrine, he's given away his information. But John Roberts, in this case, raging liberal, votes with the court's 4 liberal members and actually says no. In this instance, in this narrow instance, so he's not making a huge sweeping finding, but as to these kinds of records, the cops are going to have to get a warrant under the Fourth Amendment. And it's interesting because it's of a piece with this long line of cases that John Roberts has been really, I think, very, very interested in sort of updating privacy law beyond what the framers thought it might sweep in. And so John Roberts is very, very much writing an opinion where he says we have to update the way we think about the Fourth Amendment to jibe with modern day technology, and people can't just throw their phone in the river. I mean, we just don't live in a world where you can sort of say they're agreeing to give this information away, but they're in fact not. So let's think more carefully about these old doctrines and whether, the rule that used to apply to your bank information can still apply to your literally locational interests, minute by minute, day by day. I don't think the case stands for a lot more than that. I think that there was a general sense of hooray, liberty and privacy win. But I'm not sure that it means much more than the 4 corners of that holding. But that was our huge, massive win. Okay.
Let's give a little historical evolution for how we got to that point, because I think it's interesting. So historically, a search was when an agent of the government goes into a physical space controlled by the individual who is being searched. So if the police go into your car, or your house, or your wallet, or your purse, that's a search. And in the 1920s, the Supreme Court for the first time dealt with the issue of wiretapping, where the police would not enter your house, but they'd intercept the phone call outside your own property. And the question was, well, is that a search? And the Supreme Court, in a 7-2 decision, said no, because a search is an invasion of a physical space owned by the person, and wiretapping is not doing that. They're not going into your home, and therefore it's not a search. And that was the law for 40 years. And then in 1967, the Supreme Court overruled that decision and said that technology has changed, and wiretapping is really no different than reading mail. And reading mail would be a search because it's opening up your mail. So it's crazy not to treat this in the same way. So the court said the Fourth Amendment protects not just against physical intrusions into physical places, but reasonable expectations of privacy. But then the problem is, well, what's a reasonable expectation of privacy, right? And so the court, recognizing this is a boundless concept, right, it comes up with the third-party doctrine, which basically says, okay, if I send you a letter, and you have the letter, and the police search your house and get the letter, that's not a search of me. And nobody ever had previously thought that was a search of me. So it was a search of your property, that's not my right. And so the court basically said, if you reveal information to a third party, whether it's sending a letter to somebody or information to your bank when you engage in transactions, or the phone company when they know what numbers you've called, that's not a search. You have no reasonable expectation of privacy because you've knowingly and intentionally revealed the information to a third party. And that had been the law for the last basically 40 years, 50 years. But given technological changes, that had become increasingly stressed. So that was the issue here, is if you simply apply the third-party doctrine, then the dissenters are right. This is not a search. You voluntarily exposed your information to the phone companies, and too bad, right? And what the court was saying was, well, wait a minute. Given the changes in technology, we have to rethink this a bit. And that's what Roberts was doing in this case. And what its implications are for the future remain to be seen. But it opens the door. And since Kennedy was not in the majority in that case, you've got Roberts and the 4 democratically appointed justices. So that might actually go somewhere. Okay, the next case, and then we're going on in time, so I'll try to be quick on this, involves labor unions, public employee labor unions, the Janus case. And here the issue is, can the government require public employees to be members of unions of public employees, or does the individual employee have a First Amendment right to refuse to be a member of the union? Right? We're back again to compelled speech. This is the third case that involves the compelled speech issue. First it's the baker, then it's the abortion clinic places, now it's the public employee. So 40 years ago, in the Abood case, the Supreme Court held that the government cannot compel public employees to give money to unions, public employee unions, that they will then use for political purposes. Because you have a right not to be compelled to give money that's going to be turned around and endorse political candidates who you don't happen to agree with. But the court held it does not violate the First Amendment to require public employees to give money, dues, to the unions for purposes of collective bargaining and for representing the rights and interests of the union vis-a-vis the employer. And the court held that was a sufficiently important government interest because, first of all, it didn't want chaos among its employees, all making different claims for what they wanted from the employer. And they thought it was useful for the public employees to have a single union that represented all of them, both for the sake of the employees and for the sake of the employers. Now it's 40 years later, and in Janus, in a 5-4 decision, exact same division between the Republican-appointed justices and the Democratic-appointed justices, the 5 justices in the majority hold that it violates the First Amendment to compel employees to pay dues to public employee unions, even if those dues are only for the purposes of collective bargaining and representing the employees vis-a-vis the government employer, overruling the prior decision from 40 years earlier, saying this violates the free speech rights of the union members who should not be compelled to even provide dues to the unions for collective bargaining purposes. And again, this is a division along Republican-appointed justices, Democratic-appointed justices. Is it about free speech? Do these justices really care deeply about this free speech interest? Or is this about the fact that public employee unions tend to support Democrats? And this is a way of disempowering them. I hate to be that cynical, frankly. It kills me to say that as someone who's spent his whole career believing in the Supreme Court, but it's pretty hard to escape the conclusion that that's what's going on here. And that if public employee unions were basically Republican supporters, those justices would not be in the majority. Now, maybe the dissenters wouldn't be in the dissent either. So that's complicated. But I think that's what happens in this case. And it's, again, very troubling. about the current and future dimensions and directions of the court.
Just quickly, I think it bears saying that to the extent that I think this will eviscerate in meaningful ways the power of public sector unions going forward, it also, I think, opens the door to all unions eventually. I mean, that you can't make the distinction. I think the other point I would make, and Jeff said it implicitly, but I'll say it out loud, the court overturned a precedent that is almost as old as Roe v. Wade. And so if you're having a conversation around the next nomination, it's useful to know that the only sitting justice who says, I don't believe in stare decisis, I don't believe in precedent, is Clarence Thomas. The other justices who voted with him in this case, really with the stroke of a pen, did away with a 4-decade-old precedent. And so as a proxy for how to talk about, what do you do when a nominee is seated and says, well, I believe in precedent, this is the precedent of the court, I think is the current formulation. What do you do when the court really pretty willy-nilly just overturned a case? Okay, I'm going to do the voting cases, and they do, I think, connect, because I think this was, bar none, the worst year for voting rights, including, I think, Shelby, just in the aggregate, the 3 voting cases, and I'll do them quickly so we can get to Judge Kavanaugh, but across the boards, just momentous losses in voting. Anthony Kennedy, I think one of the reasons he stayed on the court for this extra year, you remember he was going to leave last June. I think one of the reasons he actually stayed on is he wanted to do partisan gerrymanders. He had laid down a marker in a 2004 case where he said, I think there's just something constitutionally hinky about partisan political gerrymanders. These aren't racial gerrymanders. These are ones drawn to advantage a political party. And he said, I'm looking for a justiciable standard. I want some manageable test whereby I can figure out when it's gone too far, so far that constitutional rights are burdened. And I think he actually, the court took Gill, this Wisconsin gerrymander case, and I think he really thought, this might be it. This might be the moment at which I find the standard. But he didn't. So basically, Gill had to do with this partisan gerrymander in Wisconsin. It resulted in, we had an almost 50-50 state, but sort of a 60-some to 30-some break in the seats, won after the gerrymander. And for the first time, a formula was reverse engineered that was supposed to present to Anthony Kennedy in all his glory, like, here, this is the standard. This is how we're going to know when a partisan gerrymander is so partisan that your vote effectively is meaningless. And so the standard is a mathematical formula. It's called the efficiency gap. I commend to you the many thousand articles about it that are out there. And it was supposed to be just a clean test for when a partisan gerrymander made sure that votes were being diluted in ways that are constitutionally impermissible. The argument was fascinating because it featured Chief Justice John Roberts snarking about social scientists. The angry social scientists wrote him an angry letter saying, don't call social science gobbledygook. This is really actually a pretty meaningful test for partisan gerrymanders. The court surprised us while Gill was pending. They took a second case that was from Maryland that was another gerrymander case, Benasek, and everybody said, why are they taking a second one without having decided Gill? There was some reason to believe they took the second case because it was a crisper First Amendment claim. There were some arguments that what we know that everything is about the First Amendment now, so there was some reason to believe that your associational interests were being burdened in a way that might have been more interesting than the right to vote. The court, and also the Maryland gerrymander was just one district, and it was Democrats who'd gerrymandered a Republican out of office. So it looked like maybe we could be fair. We could have, a Republican gerrymander, a Democrat gerrymander. We could have a speech issue. We could have a voting issue. The court surprised everybody by just not deciding it. So unanimously, the court says that the parties in Gill, in the Wisconsin gerrymander case, just don't have standing to sue. They have not suffered what is called a cognizable injury. They haven't been harmed. So they kick the whole case back to Wisconsin and they say, more or less, find us somebody who actually was hurt by this gerrymander. Elena Kagan, in her concurrence, more or less says, let me take you by the hand and show you what that's going to look like. She more or less like painted a picture of how to maybe succeed if Anthony Kennedy doesn't retire and his vote is still in play. But I think that, and then they kicked back Banasek, the Maryland one, and said, well, we can't decide this because we couldn't decide Gill. The other case so basically we still have no law of what is a partisan gerrymander, and we've lost Anthony Kennedy, who I think would have been the fifth vote to even look for such an animal. So you are going to see a huge uptick in partisan gerrymanders. Interestingly, this is one of those places, and we should have said this, where state Supreme Courts are sort of rushing in to fill the void. And so the Pennsylvania Supreme Court took it upon itself this year to strike down a partisan gerrymander in Pennsylvania. I think look for some of that. The other case, just briefly, has to do with vote purges. So this is this Ohio vote purge case that essentially is a way of kicking voters off the rolls. And again, surprisingly, it tends to be minority voters, young voters, elderly voters, people who tend to vote Democrats who are overwhelmingly thrown off the rolls in these purges. So the issue in Houston is that Ohio came up with a voter purge scheme, although several other states are doing similar things, where they said, we understand that the federal voting laws do not allow us to purge voters for failing to vote. So in this country, we do not have a use it or lose it principle around voting. You can fail to vote for 20 years and you never lose the franchise. But what Ohio says is, we're going to take the fact that you may have moved as a proxy for, or we're going to take your failure to vote as a proxy for you've moved. So they say, we're throwing people off the rolls for not voting, but not because they're not voting, but because we assume they've moved. And Justice Breyer, dissenting in this case, says, that's crazy. You've thrown tens of thousands of people off the rolls. Not that many people have moved. But the state says, look, we have a legitimate interest, a statutory interest in keeping our voter rolls clean and working. And so what we do in Ohio is if you don't vote for 2 years in one cycle, you get a little card at your home. It says, hey, you didn't vote. If you fail to return the card, as most voters fail to return the card because mail, then the state, if you don't vote for the next 2 cycles, the next 4 years, you're purged. You don't find out that you're purged until you go to vote. And so there were plaintiffs in this case, one of whom was serving in the military and didn't know he'd been purged, but plaintiffs who really didn't know they'd been thrown off the rolls. And what the state said was, this is perfectly permissible because we are giving them an opportunity to respond, and we're just assuming if they don't vote, they've just moved to Montana, like all Ohioans. So the court, this was another incredibly troubling 5-4, totally down the party lines that Jeff has outlined for you. 5-4, the court says this system of purging is fine. And so we're going to just see many, many, many more of them. This is another one of those cases. I mean, one of the through lines of this year is like Sonia Sotomayor sets her hair on fire. And this is one of her dissents where she more or less just says, this is insane. I mean, the racial impact alone, like how can the court just completely blinker itself to that? But you're going to see a huge uptick in purges that look a lot like this. And the third one that I'll just talk about for one little second is a Texas case that came down. This is a racial gerrymander that comes down on the anniversary of the Shelby County decision. And in this case, the court finds that there's actually there's a whole bunch of racial gerrymanders, and the court's fine with all but one of them, but also sort of changes the standard so that is almost the showing you have to make post Shelby County that there has been an intentional gerrymander is almost unmeetable by the plaintiffs. So in the aggregate, those three cases together really do mean that the problems that we now see in democracy, everything that Jeff is talking about polarization and about vote dilution and about what feels more and more like minority rule, presidents who lose the election and seat the Supreme Court justices, but also a Senate that is not representative of the majority population. We're seeing those interests start to blend together with the court making decisions that continue to put a thumb on the scale for who can vote. So these all three, I just think this is the untold story of the term, that these cases work together to sort of preserve minority rule in voting in ways that I think we're going to be feeling for a very long time.
I'll just add briefly, the interesting thing is 3 of these cases we've talked about are about intent of the legislature or of the executive. And as I said earlier, one of the challenges courts have is when do you invalidate something because the intent was impermissible? How do you know what the intent was of a legislative action or an executive action and so on? So in the Master Beats Cake Shop case, the court finds that the Colorado Civil Rights Commission had an animus against the particular religious beliefs of the baker, and therefore, because of that intent, it's unconstitutional. And obviously in the Muslim ban case, the travel ban case, the court says no, we're not going to look into the intent. Really, it's perfectly fine. In the reapportionment type cases and other voting cases, right? The challenge is, well, how do you know whether the effect of the laws, which are not even on race or on party, right, was intended, and how do you know it just wasn't, well, the way geography was set up, or it was just inadvertent? And that was part of the challenge in the gerrymandering cases. How do you come up with a way of figuring this out? And that was the gobbledygook in Robert's characterization that the social scientists had come up with. They'd come up with a test in which you could basically say that the odds on this happening for any reason other than intent are so low that we have to assume intent. And the court was not all that willing to embrace it. And with Kennedy gone, it's not very likely that the 5 Republican-appointed justices who will be there are going to be willing to go down that road. And this really is a deep threat to the nature of our democracy. You know, the Warren Court, when it got rid of one person, when it insisted upon one person, one vote, was trying to move in this direction in an important way. And it's obvious that partisan gerrymandering has to be unconstitutional. It's so directly a threat to the core principles of a democracy. And yet these justices just aren't going to go there because it's frankly not in their political party's interest. And I hate to say that.
So let's shift gears for a few minutes and allow Dahlia and Jeff to talk about the future of this court and where it's going given the Kavanaugh nomination. I'm looking at some very interesting questions, is all I can say. Some complex and some going for the throat, so to speak. So I'm going to try and sort some of these out so we can take some of them. But let's start with Kavanaugh, because some of these actually relate to Kavanaugh. And also, if you want to bring in some of the events of the day, we can go to that as well. We've got about 15, 20 minutes. I think we can stay a little longer if you wish, but we want to try and end as close to when we said we would as we can. And so I'd like to get to at least a few of your questions, if we can. Okay?
Okay.
So.
So if if Brett Kavanaugh were nominated in a situation in which Antonin Scalia died after the election of Donald Trump, I would have no qualms about supporting his confirmation. I think he's qualified, he's smart, he's a good judge. I don't agree with him, but I don't think that in itself should be a reason for denying confirmation. To me, the critical issue is what the Republicans did to Merrick Garland for purely political reasons, and how that completely distorts and undermines the credibility of the court, and somehow or other, they should not be allowed to do that. And they've manipulated things by getting rid of the Supreme Court filibuster, and when Gorsuch was nominated, and now it's even worse because it's now adding a fifth justice to replace Justice Kennedy. So to me, that's the critical issue. And I do think that a Supreme Court with Judge Kavanaugh on it will be considerably to the right of what the court has been up until this point in our history. I think that those 5 justices represent no more than 20% of the views of the American legal community about how to think about constitutional law. I doubt that much, but maybe 20%. And yet they will now be 55% of the Supreme Court of the United States. And I think that's deeply troubling. And I don't know if there's anything that can be done about it, but I think that sensible members of the Senate should take a deep breath and recognize that this is a critical moment in terms of preserving the credibility of the court as an institution. And in the same ways that Democrats, when FDR tried to pack the court, refused to do that because they understood that was damaging to the nation, both Republicans and Democrats, in a sane world, I won't even say an ideal world, in a sane world, would step back and say, we cannot do this. This is not the way things should go. And what I had proposed in an op-ed, which I totally, I think, unrealistic, but was that the members of the Senate Judiciary Committee, or at least the moderate members, should say that we will not confirm anyone who's not supported by at least a majority of both the Republicans and the Democrats on the Senate Judiciary Committee. And let's get another Souter or another Stevens or another Garland on the court and get, at least in this moment, away from this polarization and politicization of the Supreme Court. Not only because I think there's a better and worse form of constitutional interpretation, but because I care about the court as an institution. And I think we're on the verge of destroying it.
Yes. It almost goes without saying, but I'll say it anyway. What we are living through is the consequence of a 40-year laser focus by the Republican Party, starting with Ed Meese. I think Jeff described it. This has been the number one issue. It has been messaged effectively. It has been organized around. Donald Trump was not kidding around when he would go to his stadium rallies in 2016 and say, I don't care if you hate me. You're all going to vote for me because of the court. And he meant it, and he was right. And this is where I sadly say that Senate Republicans were running for office in September of 2016 on the predicate that if Hillary Clinton won the election, they would hold that seat open, Antonin Scalia's seat open, for 8 more years. Openly running on that this seat, and they would go down to 6 if we had justices at the time who were 83, 81, and 79. This was not a trivial possibility that whoever was seated, whoever won the presidency, could have 2, 3, 4 seats to fill. And Senate Democrats, with 1 or 2 exceptions, did not run on this issue. Didn't message it, didn't explain it, didn't care, didn't fight for Merrick Garland, didn't drape their bodies across the Senate and say, no. So in some ways, and I say this with zero joy, but my nervous breakdown started a year before yours did, because I felt that Merrick Garland set down a line that could not be repaired. And I think that the notion that everybody could be sanguine because Hillary Clinton was going to win and get 5 seats was just a bad bet. And not just a bad bet, but I think that we utterly failed as Democrats to explain to people that if you care about the environment and you care about workers' rights and you care about the right to vote and you care about reproductive rights and you care about unions, there's one thing that you have to vote on. And all the exit polls in 2016 showed that for the percentage of, I think it was about 20% of the electorate who really prioritized the Supreme Court as their issue, by a 2-to-1 margin, they broke for Donald Trump. And I think that is inflected with faith and, religion in ways that are incredibly problematic and interesting. But I think the fact is it was just a failure of organization and messaging that came home to roost. So that's my incredibly depressing take, which is even more depressing than yours, I think. But I do think that the one really important thing to say here is that Brett Kavanaugh has a 12-year record. He has, in that sense, Amy Coney Barrett would have been a very hard lift because she has an 8-month record. We have 12 years of writing from Judge Kavanaugh, including, by the way, things that he's done in the last year and a half when he was not on the top 20 list. And I think he started writing some really strange and weird things because he was not on the list. And so we have his opinion and dissent in Garza, which was the teen abortion case in Texas, to mind. There's some really new stuff in there. I think we have his speech that he gave at AEI, September of 2017, where he cited the Rehnquist dissent in Roe as his sort of preferred way of thinking about privacy rights. There's a lot here. And so put aside his expansive record, and I don't just mean, we got very hung up on that 2009 Minnesota Law Review where he said the president shouldn't be subject to criminal or civil trials. That's actually not what he said, and I think we got very excited about what he was saying. I don't think that's the deal breaker. I think the deal breaker is a whole host of other cases, including, citing Justice Scalia's dissent in Morrison versus Olson, the special counsel statute. There is an enormous corpus of work that he has done about executive power and executive authority. And his view of the unitary executive, his view of the special counsel, his view about executive power is unbelievably broad. So if you can disaggregate the idea that the Mueller probe, is the issue here, from the notion that Donald Trump does not believe that anything bounds his power, and he's about to seat somebody who weirdly agrees with him on a lot of those issues, I think that's a really salient issue. And I think that the fact that he has written so much about this, and some of it is really, I think, outside the scope of what we would say is sort of the normal conversation around executive overreach, I think that's the way to talk about this. And I think that if you draw a line between that and what happened today, that's a really interesting conversation that we should be having between now and that confirmation hearing.
Questions?
Okay. Do you want to comment on today before we go into questions?
I don't know that I have anything to say about today that's not obvious.
Yeah.
In a week, it'll be old news. It's all fake news anyway.
No, I mean, I think I would just say that if folks don't think that what happened today is one of the most consequential moments in American political history, certainly since I've been a journalist, I think it is astounding what happened today. And I think that, we can talk until the cows come home about how the system of checks and balances as conceived by the framers broke. But today was, to me, just absolutely, uncontrovertibly the case. Incontrovertibly the case? I'm upset. I'm using the wrong first one. Incontrovertibly the case that we have no checks.
So on that happy note, let me try. There are a lot of questions, and they're really good questions. I'm going to try and touch on maybe 3 or 4 of them, and then we have Megan O'Malley is going to sort of close us out in a few minutes. So I'm going to bring one question that relates to the Muslim ban. The question is there an intersection between the overruling of Korematsu in the travel ban case and the inevitable cases that the court will hear on Trump's family separation policy?
That's a good question.
I don't think that the, quote, overruling of Korematsu has any meaning. First of all, he only said it's overruled in the court of history. But in any event, nobody believes Korematsu is any longer good law. And is it relevant to the issue about children and immigrants and so on? I mean, they're not U.S. citizens, so it's a little bit different. Part of what made Korematsu so problematic was the fact that it was U.S. citizens who were being interned. But I wouldn't attach anything to that. I think it was just rhetoric.
Yeah, I think there's a really good argument to be made that overruling was just dicta.
Yeah.
Just nice words. But I don't think that it had any sort of formal salience. And I think in a strange way, the problem that beset Korematsu, which was that the Justice Department lied, is the problem with the travel ban case.
The other interesting thing, by the way, about the Korematsu references is I'd love to know whether it came first in Sotomayor's dissent or whether it came first in Roberts' majority opinion. Because they both talk about it, right? Sotomayor said, this is like Korematsu. And he says, we're overruling Korematsu. And I just have no idea which came first.
Well, I know that Neil Katyal, who argued the case at every stage,
Right.
invoked Korematsu in his
Oh, he did.
closing. So I think it had become sort of the poem
Okay.
of the resistance. But I don't think it has any formal.
So here's the follow-up question on the Becerra case, the pregnancy center case, which is, so can OSHA force companies to post safety warnings, or is that an imposition on free speech?
I think if you apply the precedent in a straightforward legal way, it's unconstitutional. I mean, I don't know that they'll do that, but I think that if you read that opinion and you just neutrally try to apply it, I don't think there's any way to distinguish the two cases.
Justice Breyer, in his dissent in Becerra, talks about all these states that have these mandatory scripts and says, he said it at argument 2, what's sauce for the goose is sauce for the gander. If you can't force a clinic to post, truthful information, then doctors should not be forced to give warnings that have been, medically debunked about the association between breast cancer and, or suicidal ideation and abortion. So I think his dissent is a call to say all of those laws should be struck down. Although interestingly, the states, the jurisdictions that have struck, tell me if I'm wrong, Jeff, but where they get struck down, and this is so interesting, it's the speech interest of the doctor, right?
Right.
So this is very much, it kind of hews back to Roe, where when you read the Roe opinion, like the real anxiety for the court is this doctor and like this incidental person who's carrying a baby.
Right.
But the speech interests of, it's such a fascinating problem because I think that all of those cases, if I'm correct, turn on the doctor's interest, which
Well, it's
is
the doctor who's being forced to speak.
yeah,
So,
yeah.
right.
So, and this question was actually directed to you, Jeff, but I think you both may want to weigh in on it. Could you share your any thoughts you have on Justice Kagan's dissent in Janus and the idea of the conservative justices' weaponization of the First Amendment?
So I think what Kagan is referring to there is there was an understanding about the core meaning of free speech for a long time about basically political speech and socially oriented speech, but not including commercial speech or corporate business-related speech, was not thought of as part of the protection of the First Amendment. And the Supreme Court had held in the 1940s that commercial advertising wasn't part of the First Amendment. And I think what Kagan is referring to is that in the last 25 years or so, the conservative justices have expanded the scope of free speech to go far beyond its traditional focus, to include, for example, the political speech by corporations, commercial advertising by corporations, and the notion of coerced speech by the labor unions in this context. So I think what she's seeing is that what she's suggesting is that the conservatives are using the concept of free speech to further conservative political goals, rather than looking at it as what is the First Amendment really about and what are the boundaries of it. And I don't know that I necessarily agree with that, but I think that's probably a pretty accurate characterization of the reason for the dramatic expansion of the protection of free speech. And so in that sense, I think she's probably making a very critical and fair point.
I would just add my fun fact that last year, if I were sitting here, I would have said, watch that split between Sam Alito, Neil Gorsuch, Clarence Thomas, who tacked to the right, and Chief Justice John Roberts and Anthony Kennedy, who actually had drifted to the center of the court after Scalia died. And I'd said, that's the schism to watch, because I actually thought that's where the travel ban was going to break. Mm-hmm. Nothing of the sort happened on the right wing of the court this year. Interestingly, the split at the court this year is between, to the extent there is one, but there is one, Sotomayor and Ginsburg, who are just out. They're just done with it all. And I think I compared it last week to sort of like the red hen. Like, they're just like, no, I'm not serving you, Sarah Huckabee. Like, I'm not doing like norms and courtesy and respect anymore. They're just bristling with anger. And then, you know, Kagan and Breyer, who in several of these cases vote with, you know, either the majority or vote with the moderates to form a bloc. And I think, you know, and it's a whole other conversation, but it's incredibly interesting that Kagan's long game, I think, always had been get to 5. Just, you know, that was what she was playing. And if it meant writing narrowly, getting something that is a little less expansive, but getting Anthony Kennedy, that was worth it. And what's interesting is if you look at those 5-4 splits this year, that strategy doesn't win once. So I just think, watch in the future, because I think psychologically it's very interesting that at the same time the country is having this debate about civility and norms, and do we try to work toward the middle, and do we find consensus, and do we try to have sort of presumptions of good faith going forward, or do we just give up? I think in a lot of really intriguing ways that's starting to play out on the left wing of the court.
Yeah, I want to make a point about the notion about what leads justices to do what they do. Because I've been suggesting throughout that I think the conservative justices have been acting in a way that is consistent with the political interests and values of their party. And I don't want to suggest that that's true across the board for all justices. So in my view, there is a principled way of thinking about constitutional law that goes back to the framers and basically recognizes that the reason you need judicial review, particularly in the realm of individual liberties, is a distrust of majorities. And you need that judicial review in particular in 2 circumstances. One of them is a situation in which the majority is being intolerant or indifferent to the interests of marginalized groups in society. Either as a matter of hostility or as a matter of indifference. And the other is in situations where a particular political majority takes control of the branches of government and then manipulates the political process in a way that will perpetuate its own power. And this is something the framers talked about, it's something the Supreme Court in 1938 talked about in its famous footnote 4. And I think if you look at those 2 principles, and you look, say, at the Warren Court, or you look at the votes of most of the liberal justices in the years since then, they follow pretty closely those concerns. They tend to be activist when those two issues are implicated, and they tend to be much more deferential when they're not. And I think that's a principled approach to how courts should behave. Conservative justices, in fact, you cannot predict how they will vote. It has nothing to do with originalism. If you play out originalism, it doesn't get you there. It has nothing to do with judicial restraint. That was true for some of the Nixon appointees, but it's no longer true. Conservative justices today are every bit as activist or more so than the liberal justices. And the plain and simple fact is, if you ask yourself, in the highly controversial cases, the kind of cases we're talking about today, how would I predict the liberal justice will vote and how will I predict the conservative justice will vote? You will get accurate votes most of the time with the liberals if you take those two principles and apply them. And you will get accurate results with the conservative justices most of the time if you ask, what would the Republican Party want?
Wow.
And I hate to say that, but I think that's quite true. You can do the game. I've done it with lots of colleagues, lots of cases. It works remarkably and depressingly well.
So, I think in watching the time, we're going to stop. If either of you have any other remarks you want to make. I apologize for not getting to all the questions that were submitted. They were great ones, and I appreciate that. I'm going to call on Megan O'Malley, who is one of the founders of Courts Matter Illinois, who's going to close us out today.
Thank you, Carol, and thank you, Jeff and Dahlia. You guys were amazing, and I feel rather silly on you. But you asked me to address everybody about what you do and the importance of savings notice. Jeff, something that you said at the beginning resonated with me, which is that you said the courts were, in the beginning, the Supreme Court was viewed as the champion of our rights, the enforcer, and they weren't supposed to be partisan. And that's true, because the courts have always been our great equalizer. It's written right into the Supreme Court building, etched in stone, equal justice under law. It's written into our Constitution, equal protection under law. What many of you might not know, it's in the judicial oath of office that the judges will do equal right to the poor and to the rich. The courts were always the great equalizer. Lady Justice is blind. You and I can go up against the largest corporation or the government itself, and the judges see us on equal footing. That's how it's supposed to be. That hasn't been how it's been in recent modern history. And it's getting, I agree with you, further and further away. And one of the things that, I'll part ways a little bit with you, is that Brett Kavanaugh certainly has the pedigree, right? He's Ivy League, he went to high school at Gorsuch, he clerked with Gorsuch, he co-counseled Bush v. Gore with Roberts. He's right in there, right? He's got all the qualifications and the pedigree. What he isn't is a consensus nominee. When he was nominated to the DC Circuit, he did not get 60 votes. Until Neil Gorsuch, we had a rule that the Senate followed, that those Supreme Court justices would meet a 60-vote threshold. And there's a reason for that. The reason was we wanted to give at least some voice to the minority party, whether they be Democrat or Republican. And that helped to ensure that the courts remain the great equalizer. What we have now is a hyper-partisan nominee chosen from a list of 25 from a special, very well-funded special interest group that doesn't see the courts as the great equalizer and there to apply the law and enforce the rights of individuals as much as corporations. What we see now is a hyper-partisan group. The president's outsourced to these groups to say, tell me who you want. And what we have as a result is a nominee who... I practice in the area of employment discrimination. And the day after Kavanaugh was nominated, we got a newsletter from one of the most prominent labor and employment firms in the nation that bragged that they had looked at all of Kavanaugh's opinions and that he ruled with the corporation and the employer in virtually every single one. Their words, not mine, were that he went out of his way and went the extra mile to rule for employer corporations. What they concluded was that he would be, if confirmed, this court will go from a reliably pro-business court to being solidly pro-business. That, to me, does not sound like equal justice under the law. It does not sound like the great equalizer. So what can we do to ensure that we get a consensus nominee, somebody who would, under different circumstances, if we hadn't changed the rules, met that 60 vote threshold. What we can do, and I know it sounds dark and dismal and we've had a lot of bad news, but I'm here to tell you we can do it, right? There's one thing that was defeated under the Trump administration, and it was the repeal of the Affordable Care Act. Why was it defeated? Because you and you and you and you and you and you and everyone in this room made a phone call. So we have to do the same thing. We have to be active, we have to pick up the phone, and we have to call our senators, and yes, even our senators, because even though Durbin and Duckworth will probably inevitably vote against Kavanaugh, and insist on a consensus nominee, they need to hear that we care. And you heard Dahlia talk about, this is a 40-year campaign by the Republican Party to gather judicial voters. We need to be judiciary voters because the judiciary is the issue that affects every issue. Federal judges decide issues relating to your voting rights, your civil rights, LGBT rights, gun control, your environmental rights, everything, reproductive health, every single thing that affects you is decided by federal judges every single day in the Supreme Court and the lower courts. So we need to also recognize that these issues are extremely important. The courts can enforce our rights or they can take them right away, as we've seen in this court. So call your senators, have your friends and family call their senators, especially if they are in states right now that are critical. Those states, of course, would be Alaska and Maine, but as well Indiana, West Virginia, and North Dakota. So if you have any friends, any family, any third cousins, any barber's third cousins who live in those states, please talk to these people. Talk to everyone. I talked to my Lyft driver today. I asked him, can I ask you a question? Have you ever cast a vote about the Supreme Court or on judges? He said, no, I don't know what you're talking about. And I had a little chat with him. So, just talk to everyone you know. Tell them why the courts are so important as the issue that affects every other issue. The other things you can do, vote, register people to vote, get everybody you know registered to vote. If they happen to live in the great state of Ohio, where I'm from, remind them that you might be purged, so please re-register. Sign up, join Courts Matter. I think there was a sign-up sheet, but, Courts Matter has a great, we put programming out. We have a training thing coming in the fall. Follow at Why Courts Matter, at We Demand Justice on Twitter, great resources. There's indivisible events, to talk to your Senate offices, look for those protests. The biggest issue is we all need to make our collective voices heard. Just like we did with the Affordable Care Act, we need to say, it's our court. It's not your court. You don't own that court. You don't get to put together a list of 25 people that will be an extension of the legislative branch. I love the courts. I love our judges. I practice in federal court every day, and they take their job so seriously. And they read these things, and they may not agree with me politically, but darn it, they do a good job. And it breaks my heart to see these courts move to a partisan place. That's not what they are. They are our courts. So use your voice and join the team that says we are taking back the courts because restore equal justice under law. So when you leave here today, put Senator Durbin and Senator Duckworth in your contacts, call them periodically because it matters. They need to hear from you. And I will thank you guys again and go be a judiciary voter.